there is indeed, let me say that to just follow up, there is indeed a legal war going on, especially in the area of copyright or other intellectual property right. This is the case. And there are quite extreme positions, as we said. There are supporters of alternative concepts, and I will come back to that later, like Creative Commons. And there are also the advocates of the traditional copyright system. When talking about the legal implications of your business, of your everyday life, you should imagine that you have a double role, you have a double face towards copyright, in the sense that you are perhaps a producer of creative works and have an interest in these works and the benefit of these works being protected for whatever amount of time. Can easily discuss that. On the other hand, you are a consumer of copyright, a user of copyrighted works, and perhaps have an interest in getting free access, being able to use those works quite widely. So there's always, and that's the basic of copyright perhaps, and the discussion on how this will develop in the future, there's always a balance between the interests of the creatives in their works being protected, in their, of course, also financial interest in earning revenue from their works being protected, and in the rather public interest of getting the most access possible to that. I wanted to talk to you about innovation and law, as this is a conference on innovative journalism, and wanted to raise three aspects of this relationship between innovation and law. The first question, rather, is does law really block innovation? This is perhaps a thinking you may have. The second thing is it perhaps the way that law in itself is innovation? If yes, to which extent? And the last aspect, dealing with the situation we have, not knowing how the situation will develop in the future. And to be honest, and to say that as a first thing, I don't know how copyright regime, be it here, be it in any other jurisdiction, will develop within the next 5, 10 or 15 years. The first aspect, does law block innovation? And from the introduction Winfried gave, the perception is often that law, intellectual property law, and IP lawyers like me, we usually block innovation. We say, no, you can't do it like that. No, this is prohibited, this is illegal. So, of course, there is a certain blockade in law, because law sets a limit, sets a framework of what is allowed and what is not allowed. What I wanted to briefly present to you is the or parts of the outcome of a study that was commissioned by the EU Commission on interactive content and convergence, implications for the information society. The study was done throughout 2006 and published in October. It's freely available on the EU Commission's website. And this study aimed at to identify and assess the impact of potential economical, technical, and legal roadblocks that may hinder the exploitation of digital content across new distribution platforms and technologies. For this purpose, there was a limited amount of content that was specified. Digitalized content that was distributed throughout various platforms like mobile, like networks, and it was various parts of content, inter alia, television programs, radio programs, and also publishing content. And the study tried to get an overall picture in doing desktop research, doing interviews with stakeholders from various industries, and trying to identify what does you prevent from sharing, from exploiting your digital content more than it is now. Is it for economical reasons that you don't have enough revenue? Is it for technological reasons that access to technology is limited with the potential users? Or is it indeed, and that's the topic for today, is it indeed the legal framework that prevents you as a stakeholder from sharing your digital interactive content? And it was a quite complex task. I have, I think, part of the study here, so it's a whole lot of paper if you print it out. Nevertheless, it's quite interesting. There are some quite interesting industry overviews as well. We did the legal part, and this was quite an endeavor too. Just to have a look at who is involved in this process, who are the players that may have a legal interest that is to be protected or balanced against each other. To start with the whole process, there are the copyright holders. These are the creative people, like journalists, like writers, like musicians, or like filmmakers that do creative work and that create creative work. Then on the next step, we have content providers that collect or market content, as well as content aggregators and digital distributors. Then there are the access providers, and at the very end, the consumers. So there are various steps nowadays that content has to go through before it comes to the consumer. Then there are bodies or regulative bodies like collecting societies that are taking care of the interests of copyright holders in raising copyright levies, for example, from IT vendors, from network service providers, or from consumer electronics manufacturers, and that redistribute those levies to the copyright holders. And we have the whole area of regulation, so saying this service is allowed under certain circumstances. The next thing that the study identified were the major obstacles preventing distribution of digital or interactive content. And the first two were rather technological issues. The most important one was consumer access to technology. So let's say broadband penetration varies even within the European Union from country to country quite significantly. The next one is an economic obstacle. That means access to funding and consumer acceptance. So the development of pricing models for content, the development of technological solutions for micropayment and such may be a roadblock for that. And the next, let's say, no, sorry. The next things, the next obstacles were purely legal issues. Inter alia copyright, so the definition, for example, of new media rights. If you imagine to be a content distributor, you have a platform for interactive content, and you address a copyright owner or a content holder to license this content, to distribute it on your platform. You have the practical problem of how to define the rights that you need, the rights of use that you need for this special purpose. And we have experienced in our practice during the last 5 or 6 years various lawsuits that dealt with exactly this issue. That two parties agreed and meant they had a clear agreement on the licensee using a certain content for a certain purpose. And after some years, it turned out that they had a completely different understanding and had to go to court to clarify the situation. So there is, from a legal point of view, an operational issue that the law or the legal terminology often is not able to cope with the technological development and put it into really legally binding contractual relationships. The next thing, of course, is digital piracy. And the study that, of course, covered the whole range of EU member states stated that there is a